Hello everyone, my name is Shivi Rajput and I'm a partner at Stowe Family Law. Welcome and thank you for joining me for this webinar on matrimonial and non-matrimonial resources in divorce. Where are we post Standish? In this session, I intend to provide you with an overview of the process of dividing up a couple's money and property on divorce, focusing on how the law in England and Wales differentiates between two types of assets, those which are matrimonial and those which are non-matrimonial. This distinction can make a significant difference to the outcome of financial proceedings. We'll look closely at the first instance decisions, the Court of Appeal and the Supreme Court judgments in the Standish saga, which provide the most current guidance in this area of the law. This is a 1-hour webinar and there are 4 multiple choice questions at the end to complete your learning. A copy of the slides I'm using for today's session are available to all delegates, and on the penultimate page of the slides, I've shared my email address in case you have any questions. So let's have a look at today's course aims. This webinar is going to cover the following. We will have a look back at the principles of needs, sharing and compensation as established by the cases of White and White and Miller and McFarlane. We'll understand the difference between matrimonial and non-matrimonial assets and how the court deals with them. We will look at the special status of the family home, when non-matrimonial property will be invaded, how the court deals with arguments of special contributions, post-separation assets and accrual, the treatment of inherited assets. We'll look closely at the impact of the Standish saga and where we are now, including an examination of the first instance, Court of Appeal and Supreme Court decisions. We'll look at how nuptial agreements can protect non-matrimonial assets in divorce. And finally, there will be some practical guidance and a checklist on how to approach cases where arguments as to matrimonial and non-matrimonial property may arise. We'll start by journeying back to the landmark House of Lords decision in White and White in 2000, which made achieving fairness a top priority when dividing finances on divorce. Many practitioners agree that this judgment marked the most fundamental change in family law since the 1970s. Prior to this judgment, the norm was that a claimant's spouse, usually a woman, would have his or her needs reasonably met, but that was all. There was no arithmetic calculation for the division of matrimonial assets, and it was often the case that a wife would receive considerably less than 50% of the matrimonial assets, which was potentially discriminatory against women and failed to protect non-working mothers. White and White, the facts of which we'll consider later, marked a significant change in this regard. Lord Nichols emphasised that there can no longer be gender discrimination when determining the allocation of ancillary or financial relief.